Hello, everyone, and welcome to the webcast. My name is Laura Cox, and I'm with the Association Corporate Counsel. For our speakers, we have Chris Smith, who is a shareholder with Brooks Cushman. We have Aaron Chesta, who is legal counsel with Dassault System America. And we also have John Landini, who is a shareholder and co-chair of the cybersecurity group at Brooks Cushman. And I'll turn things over to John to get us started. John, take it away.
Great, thanks, Laura. Today we have quite a few different provisions that typically come up in a lot of either IP type licensing or technology type licensing, in particular software maybe licensing. And while we're going to try to go through as many of these as we can, depending on time and depending on how long each one takes, and if there's questions, we may or may not be able to get to the last couple, but the content is there, and we're always happy to answer any questions if we can't get through everything today. So with that, let's toggle forward to our first provision, the grant provision. And the grant provision in any technology license is probably it probably is the most important clause with respect to in particularly IP type licensing. It has several significant implications for the commercial use of possibly an invention. It can toggle between copyright rights and patent rights. And there's many different grants that could be given in a technology license, especially with dealing with IP. I mean, you can have the right to reproduce technology, to modify it, make derivative works, to use, to make it or have it made. And those are just a few illustrative types of grants that could be brought up or be introduced in the grant provisions. And one of the other aspects of the grant is whether or not it's going to be an exclusive or non-exclusive type license. The exclusive, you might have a licensee will have the right to make, use, or sell the technology. Non-exclusive, the patent holder might grant the license the right to additional licensees or to other users. The grant clause typically also includes the geographic region where the agreement is going to be restricted to. I mean, it could be a state, city, U.S., international, and that's pretty important depending on what type of grant you're giving. If it's a patent right, you might want to restrict it to the U.S. If it's involving international patents, you might want to expand it out beyond that. So the grant provision comes into effect, and there's a lot of important aspects interplaying there. One of the other important aspects that interplays is when you're talking about patent licensing is, looking at the particular patent of the technology and looking at the family. A lot of times patents are an extended family, and you might be looking at a child patent, and it might have a parent or grandparent. It may have, distant cousins. Patents could be like almost like a family tree where, you have the original patent and it stems off in many different branches. And the reason I bring this up is if you're only licensing one of the patents, if you're licensing one branch of a patent family and you negate to license the rest of the patent family from the other branches, you may not have rights, exclusive or non-exclusive to those other patents in the entire patent family. So, and that might be something you do want to do. So it's just, when you're looking at technology, when you're looking at the grant clause, when you're looking at whether it's non-exclusive or exclusive, and you're looking in particular at patent licensing, you got to take into account all the different aspects, whether or not it is part of a bigger family, whether or not you want to license off just a section of the family, the entire family. If you're on the other side, whether or not you want a grant of a license to the entire family or portion of the family. So with that, let's move to the next slide. So one of the aspects of the grant clause can be, whether or not there's upstream or downstream rights to it. And just a couple of issues that sometimes come up is in particular one to a foundry right. And there, what it is, it's essentially, whether or not a licensee has the right to make the product for a third party and sell it under their third party's name. And the seminal case there is the Cyrex Intel case. In particular, there, Intel sued another company, Atmel, for patent infringement because Atmel was using a license that was given by Intel to Sanyo to make a product. And Amtel was having Sanyo make the product because Sanyo was licensed by Intel to make it. But Amtel was having Sanyo make it, and then they were selling it using their own name. So Intel came after them and said, no, 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 no. You can't do that. You can't have some third party who's licensed by us to a certain patent make a product for you and then sell under your own name. You have to be a licensed person to us, and they weren't. Sanyo is a licensed person, and they can't sub-license away our rights, and the Fed Circuit agreed with them. So that's just one type of third-party upstream right that you got to look at. So it's something you want to make sure when you're looking at these type of licenses, you want to be very clear on who is getting licensed and make sure there's no sub-licensee rights where they can go off and take their license and then make the product for someone else who can then sell it, especially if it's a competitor. So that's just something you want to keep in mind. And if we move to the next slide. So the other aspect is downstream rights. And here the case that came up a couple of years ago, the Core Brace case, it was kind of a play off the Intel case. They were trying to make an argument that it was a foundry type right, but here the Fed Circuit kind of looked at it, and here the facts were a little bit different. It was Seismic was a licensee to the patent, and they went off and they asked somebody to make the product for them. That third party made the product, and then they came back, gave it back to Star, and Star went out and was selling under their own name. Core Brace said, no, you can't do that. That's not right under Intel, and the Fed Circuit disagreed. They said, the facts are a little bit different. Here, they're a direct licensee to the product, and they're asking a third party to go out and make it, and now they're going to sell it under their own name. So they're actually allowed to, under their license, go out and have somebody make it and sell under their own name. So here it comes down to, if you don't want to give that right, if you don't want a licensee to be able to use a third party to make the product for them and allow them to sell the third party product that's being made, you got to specifically modify your license so that it excludes that, so that it's not part of something that gives those type of third party have made rights away. So these are two just slightly variants of the third party upstream downstream portions of the grant provision that you might want to look at when you're looking at what you're licensing, how you want to license it, and who you want to allow to do certain things with that license. If we move to the next slide, I'm going to turn it over and let Aaron talk a little bit about software license grants.
All right. So again, going back to the license grant, in the context of software, a software license grant describes the scope of rights granted to the licensee in much the same way as an IP license. The grant typically permits the licensee to use the software in accordance with the terms and conditions of the agreement. So you would have the right to use. It may include the right to modify, copy, distribute, or sub-license the software. So you would need to determine what the scope of the license grant is and whether it aligns with your business needs. That will typically require you to read some of the definitions and understand how they build your scope. So when we're talking about the scope of use, the most important thing may be who can use the software. So towards that, you need to know, first of all, the license model. So software can be licensed under different schemes. For example, named user, where each individual person using the software has to have a license, or concurrent use, where a license can be used by multiple people, or an enterprise or system license, where anyone in the entire company can use the license. And then you also need to look at how user is defined. Are the licensee's affiliates permitted to use the software? Are licensee's subcontractors permitted to use it? Another point in the scope of use is where the licensee can use the software. Are there any geographical or hardware restrictions? So for example, in the case of on-premise software, does the machine on which the software is installed need to be located at the licensee's address? Does it need to be in the US? Can it be anywhere in the world? Can users use the software remotely from the internet in any country? Those are all considerations on the license, the scope of the license. Another one is when can you use it? How long can the licensee use the software? Is it an annual or a term or a perpetual license?
Often this is something that's included on the order form instead of the agreement. And if that's the case, you need to make sure the agreement references the order form in some way, so your term is part of the agreement. You also need to look at what you can do with the software. Is the software for productive or non-productive use? Now, usually you're looking at productive use. Non-productive would be an evaluation license only. You need to look whether the software is permitted for internal business use only, or can it be further distributed? Some software licenses will permit the licensee to include the licensed software within the licensee's own hardware or software and distribute that combined product to a third party. So that's called OEM software, original equipment manufacturer, and it's intended to be incorporated into another product. So for example, Microsoft Windows is a very obvious example of OEM software. Many computer manufacturers include Windows software in the computer before it's put on the shelf and before the hardware is put on the shelf for sale. So you need to think about what you need and what the license grant actually gives you. That's all for the software license grant.
Kind of piggybacking on what John was talking about with respect to the grant right, when I talk about exclusive license provisions, and John mentioned this a little bit, this is kind of a more deep dive into exclusive licensing, which is part of the grant. If you go to slide 11, please. So the reason why the exclusive license grant matters so much, or one of the reasons, is because specifically in patent law, but this also can apply in trademarks as well, is that typically there are two types of rights that can convey the right to sue under a patent. And that is if you're the owner, the assignee of the patent, or you're an exclusive licensee of the patent. And in the case of the exclusive license, which we're going to focus on here, there are different types of exclusive licenses. There are what I call limited exclusive license. And in those contexts, the licensee must join the patent owner to file a lawsuit. And then there's what I call a virtual assignment, which is a full, all substantial rights exclusive license, which allows a licensee to sue by themselves without having to join the patent owner. Non-exclusive licenses, there's no saying to sue whatsoever. Next slide, please. So with respect to what I call limited exclusive license, first off, and critical in any exclusive context, to be considered exclusive, the grant must have an express or implied promise to exclude in a particular region. It must say that, party A has exclusive rights at the exclusion of all others in the United States, let's say, for example. And that could be exclusive rights in the US to practice a particular technology covered under the license. However, and we'll talk about that a little bit more on the next slide, but if not all substantial rights in that exclusive license are transferred over to the licensee, typically the licensee cannot file a lawsuit without joining the patent owner. Going to the next slide, please. So now we've talked about limited. So the question is, what does it mean to have all substantial rights? And in that case, if the grant grants the licensee all substantial rights in the technology in the patent, that licensee will be able to sue by itself without any needing of joining the patent owner. And what the courts have typically held in this context is that the key right to constituting all substantial rights would be whether or not the licensor, the patent owner, has retained the right to sue under the agreement. So if the agreement, when transferred over to the licensee, also gives the licensee the right to enforce the patents, courts typically look at that as the key issue in determining whether that exclusive license is one that becomes what I call a virtual assignment, which allows for the licensee to sue by itself. Below here on slide 13, there are other rights, though, that a licensor can retain, and an agreement can still maintain this kind of all substantial rights transfer. For example, the patent owner can retain the right to practice the invention, they maintain financial interest in the litigation, maintain title of the patent. It's really about the right to sue that the courts are really honed in on for purposes of whether or not that exclusivity now becomes exclusivity to sue by yourself. So why this can be important is often in organizations, or one example of why this can be important is often in organizations you have multiple entities. And those multiple entities, often there'll be practicing entities which will practice the technology, and then there'll be often holding companies and such that are set up to retain the assets. There are tax benefits to that, is my understanding. So in that circumstance, within an organization, there's some strategy to be considered about who do you ultimately want to have the authority to file lawsuits on the patents. And it's common that you want the practicing entity to have rights in the patent. So if your organizational structure is though to have a holding company to retain it, you have to have a strategy in making sure that those rights are transferred to the patent or the practicing entity of the patent, the technology. And that can get you in trouble if you're not careful. So the Spine Solution case, which is cited here on slide 14, was a particular issue where you had a patent owner and then you had a sister company. Sister company filed a lawsuit, and the defendant moved to dismiss the lawsuit for lack of standing because they claimed the sister company did not have standing to sue. And the defense to that accusation was effectively that the way that the structure was organized, there was like basically, I guess it's implied, ultimately was the argument. It was the way the organization was set up. It was organized in a way that this sister company had these exclusive rights. And the Federal Circuit ultimately held that's not sufficient. Just kind of setting it up a certain way and just assuming everyone knows that this company has exclusive rights is not going to be sufficient to convey standing. So the takeaway here is, if you have a particular strategy, a particular entity that you want to have those rights to sue, do it in writing. Have a written agreement between entity A and entity B. I know that it could be all in the same organization, but they're viewed as separate entities that are separate and distinct from one another, and they need to have those transfer of rights to memorialize it and do it in writing so there's evidence of it later when this comes up. Next slide, please. And the reason why this will matter, or can matter, is that often when you get to the merit issues of a patent case, for example, if you want an injunction, typically you have to prove irreparable harm. Well, it's hard for a holding company that just holds assets to prove irreparable harm. It's the practicing entity that could suffer irreparable harm if a party is considered continued to allowed to infringe. Similarly, lost profits damages. Typically, the law allows you to have at least a reasonable royalty, but lost profit damages can be more lucrative. Again, a holding company that doesn't make or sell anything doesn't have that argument to say they lost profit, but the practicing entity does. And again, these companies are treated separate and distinct. So just because an organization somewhere in it makes a product doesn't mean that entity A over here that sells a product, that sale can be imputed onto entity B who just holds the patent right. So it's key to make sure that entity A has the rights to sue. And at the bottom, there's a link. If you want to read more about this, I did publish an article with ACC a few years ago on this point, and it cites a lot of the case law that we discussed.
So we've talked a little bit about, the grant clauses. We've talked a little bit about some of the other structures of exclusive license provisions. I know Chris talked a little bit about virtual assignments. Now we're going to toggle into a little bit more about the assignments, just because, as we were talking about with the grant provisions, when you have, exclusive versus non-exclusive, you also have many different flavors of ways to assign away the technology or ways to get an assignment for the technology. And the first one that typically comes up a lot is a present assignment or promise to assign. And what I mean here is, if you had language in there about, we hereby assign the patent rights to US patent 1234 to company X, you have to be careful. Or even worse is that you said, we hereby assign all rights to an invention that, employee X will make. So there you have something that hasn't been made yet, but will be made. And let's say employee X goes ahead and makes that invention. Let's call it, a widget. He made the widget for you, and the widget's the best widget that's ever existed in the entire world. Well, you may go on and want to file patent applications on that while the widget is being made. And, widget comes out for sale. It's a boom. You file 10 patent applications on it, and you now have patents in the patent pipeline that, might come out at the other end as a, official US patent. The problem is your assignment that you granted to someone, hereby assigns, you not only granted an assignment for that invention, you also granted an assignment for all those patent applications that now became patents. So when you're looking at assignment, a present assignment, of a future interest, you have to keep in mind that That present assignment will also probably include any type of IP protection that is later gained off of that invention. So that's just one thing you want to keep in mind when you're looking at assignments. If we can turn to slide 18. The other thing is if you're assigning away, the right to something and you say, I agree to assign or confirm in writing, or I will assign and hereby assign the present assignment of an invention. Here, the issue comes in is once you sign something away, you've signed away the rights and you don't have any future rights to do future assignments. So you have to be careful when you're doing assignments and make sure what you're assigning is you're still retaining rights to either the invention or the IP, and you're not assigning everything away to someone where you're not going to have any future rights to assign it to other people. It's a little bit akin to the sub-licensee aspect of it. If you want a license, give an exclusive license, that's great, but you gotta be careful because if you give away exclusive license, you might not have the ability to license to other people. So when you're doing assignments, it's very similar. When you're looking at it, you gotta figure out who you want to assign it to and how you want to assign it and what you're actually assigning away. Are you assigning away your right in the future to further assign that invention or that IP or right to somebody else? So it's just another provision when you're looking through these agreements, you got to be very close or pay very close attention to these assignment provisions and make sure that it is set up and structured, particularly the way either you want to receive it or the way you want to give it away. Can we move to the next slide? So just a couple other examples of language of a current assignment is, the I will assign and hereby do assign, the agrees to grant and does hereby grant, and agrees to and does hereby grant and assign. I mean, these are all patent assignments that are give a current assignment. It's not going to give away any future assignment. And this is language that's been upheld in the courts as being representative language of just current assignments. So these are, if you're looking for, language that you think would, or you're looking for language you want, I mean, it's always best to go to these type of cases and model your language off of that. So if we move to the next slide. And so here are some cases where it was creating a promise to assign. And these are more limited to typically either a client, an inventor, an employee, because a lot of times, I mean, this comes up sometimes in employment agreements where you want to make sure that whatever the employee, makes, if you're a technology company, that they're going to assign it to the company. You don't want to run into a situation where you don't have these type of clauses in your employment agreement. You have an employee who, let's go back to our widget example. He was hired by you to make the widget and then makes the widget, and he goes off and he files 10 patent applications because he's the inventor. And you say, no, you did that while you're working for us and you got to sign it. And he says, no, there was nothing there for me to assign it to you. So you want to make sure that when you're working with these type of technology agreements, when you're working with a client, when you're working with an employee, when you're working with a third-party vendor, that when you're working with them and they're coming up with inventions, or you're working collaboratively, with another vendor, that whatever is invented, you want it to be assigned to the right company. And if it's supposed to be assigned to you, then you want to make sure that right is in there. If it's supposed to be assigned to someone else, they're going to probably want to make sure that right is in there. So these are just types of languages and assignment languages that you want to be on the lookout for when you're going through these type of agreements. We move to the next slide. The last thing I just wanted to cover real quick is the scope of the assignment. And here it's more of, what inventions will be covered by the assignment. If it's made or conceived by employee during the term of employment, like the Preston case, you want to make sure that if he conceived it before, came and worked for you, and then left, and then made it after he left, that now this language here, it wouldn't be made or conceived by the employee during that term of employment. So he could have conceived it. It could have been something you wanted to hire him for because you knew he came up with a good widget, and he came and started working for you, got sidetracked, widget wasn't made, he left, and then he makes widget. That may have been something that was the terms of why you were hiring him, but because of the coverage of the assignment, in the press-on case, that wouldn't have applied. And in that case, the employee was free to conceive it before and make it after. So you would have had no assignment to that invention. So it's just, you gotta, kind of think about what you're trying to get. I mean, One caution here was about the definition of concede, as it would apply in a patent case. But what I wanted to bring up with this point is just when you're looking at these assignments, when you're hiring employees, when you're working with third-party vendors, when you're working with, collaboratively with other companies in a joint venture, the assignment is one that comes up a lot as one of the more important clauses, because you got to really figure out who's coming up with it and who's going to have what type of rights after the product or invention is made. And that comes into the assignment clause of the agreement. And with that, can we switch to slide 22? And Aaron's going to talk a little bit about software license assignment provisions.
Right. Going back to software licenses, there are a multitude of cases in the 6th, 7th, 9th, and federal circuits through which courts generally have recognized the need for a uniform rule that provides that patent licenses are personal and non-transferable in the absence of an agreement authorizing assignment. So the general rule under federal common law is that a license to copyright or patented subject matter is non-transferable unless expressly provided otherwise in the contract. And this runs contrary to the state common law rule that contractual rights are assignable unless prohibited by an agreement. So the reasoning behind these rulings is that allowing the free assignability of a patent license would be inconsistent with the goal of encouraging creativity and invention. And that's the very reason the patent and copyright systems exist, to encourage innovation. So while those cases are addressing patent and copyright, it is likely that the same rule would apply to software licenses, and federal law would preempt state law on the subject of assignability of a software license. And the SynCom case from the Sixth Circuit extends the general rule applicable to patents and copyright into the realm of software licenses. So the assumption is that they are non-assignable unless specifically stated otherwise. And if we can go to the next slide, please. So a software licensor will typically prohibit assignment of a license completely or allow it only upon consent of the licensor. This prohibition is likely based on one or several of the following reasons. The licensor does not want its licenses to get into the hands of its competitors. The transferee party may be getting an unfair deal. For example, if company A has an enterprise software license that 100 employees use, and company B acquires company A and has 500 employees that would use the software, without a prohibition on transfer of the license, company B would be able to use company A's licenses without paying anything for the increase in potential users. Another reason is that a new or domestic company may not have a healthy credit rating, and if there are still payments due, that could cause concern. Or it could have a problematic compliance history, whether that's overuse, or it could be an export control issue, even a security issue. Those are all reasons the licensor may want to prevent assignment. Licensees, on the other hand, they want to ensure flexibility for their business. So they want to be able to transfer licenses to a divested company or to continue using those licenses in the event they're acquired and merged into a new company. If the software license agreement in question prohibits assignment and you have perpetual licenses, it would be to your benefit to seek an exception to the prohibition on transfer or consent. So you could, for example, seek an exception to allow transfer to a specific affiliate, or if you know that a change of control is on the horizon, you could try to seek an exception to name a specific company to allow transfer to a specific company. You could also seek an exception to allow a divested company rights to continue use of the software for a certain period of time. I know we receive requests like that all the time at my company. So as the licensor, when you receive these kind of requests, you have to look at it from a business perspective. You know, how many more people are going to be using the license? Is somebody receiving an unfair benefit? Is this something you want to charge a fee for? And it's worth noting that in some states and in some jurisdictions, a merger is not considered an assignment under the law. So as a result, a licensee would not be subject to a prohibition or a consent requirement unless the non-assignment provision specifically provides that a merger is a type of prohibited transfer. Sometimes the assignment prohibition will just say no transfer, no assignment. Well, what does that mean for a merger? So if it's not specified, you might be in luck depending on your jurisdiction. And I did see there was a question earlier, which I will address. The question is, what is your view on software licenses where the license is more general, a plain license to use, when it does not specifically set out a restriction? For example, if I have a license to use software, which I originally used on an internal server, can I redeploy to an external hosted server under our control with the same scope of use if the agreement does not expressly prohibit that? That is an excellent question. My take would be that if your license to use doesn't define any rights other than to use, and it doesn't define user or machine in a way that expressly prohibits third-party hosting, and the third-party hosting is under, or the hosting is under your control, my take would be that the right to use does extend to that, because you're still the one using it and there's no limitations on machines. So to me, the use is extended to that situation. Good question, thank you. Moving ahead to the marking.
So another concept that comes up in specifically to patents is, when do you start counting damages if you go to litigation? And there are typically two ways that you start the clock. There's two ways of giving notice to start the clock. There's what's actual notice, which is you send a letter saying, company X, you infringe patent Y. And then there's what's called constructive notice or marking, which is where if you are a patent owner and you make a product or sell a product that covers the patent, that you have a duty to mark that product with the patent number. And then if you do that, then that puts the universe on notice. Now, the laws changed a bit. There's also the option to have a website where you list patent numbers and then you cite to the website on the product as well. The law says that that activity, when there is that duty to mark, which is when there's a product that covers the patent, has to be substantially consistent and continuous, and substantially all the products must be marked. Go to the next slide, please. So, but beyond that being a duty for the patent owner who has a product, it also extends to licensees of the patent. So if you own a patent, let's say you own a patent, you don't make a product that's covered under the patent, but you license it to third parties that do make products that cover the patent. That duty to mark extends to those licensees. And if at some point in the future you decide to assert your rights in the patent, file a lawsuit, and your licensees that had a duty to mark failed to mark, that failure can be imputed onto you, and then you can suffer the consequence of their failure to mark into your, when the timing for patent damages would begin. And that duty to mark, or that burden of proof to show that there was a marking met is on the patent owner in that situation. So the situation comes up is, what is a patent owner to do, or what does a patent owner have to do to ensure a licensee marks? And is there a stopping point where a patent owner has done what they can do and that's it? And the law says that the patentee, the patent owner, the licensor must take reasonable efforts to ensure compliance with the marking requirements by the licensee. Go to the next slide, please. And so one way that often, or one way that a licensor and a patent owner can try to enforce these marking requirements on the licensee is to have marking provisions in the license agreement itself. However, while this is not a hard and fast rule, it appears that in certain circumstances, merely having a requirement to mark in a license agreement in and of itself does not mean that you've taken your reasonable efforts and you're safe as a patent owner. For example, in this K&K Jumpstart case, the plaintiff, K&K, had licensed its patent rights to a third party, and in that agreement there was a marking provision. But besides that marking provision being in the agreement, K&K did nothing else to make sure that the third party was actually following the requirements in marking. Subsequently, K&K filed a lawsuit against a company called Schumacher. Schumacher raises a defense to damages that this licensee hadn't been marking. And only then did K&K then realize there's an issue and followed up with the licensee. And the Federal Circuit said in that circumstance, that wasn't sufficient. And this tells us that merely having a marking provision in and of itself may not be enough. Now, the Federal Circuit doesn't say ultimately that it can't be enough, but in this case it wasn't. So I think there's some ambiguity there. Go to the next slide, please. But what I think it does tell you is that merely putting a marking provision into your agreement and then burying your head in the sand probably isn't the best course of action. So some suggestions. First of all, I believe that having a marking provision is better than not having one, certainly, because one, it gives you some contractual rights to enforce. And second, it does put marking on the radar of both the licensor and the licensee. However, I think in addition to just having a blanket provision that requires marking, other steps can be taken to kind of build up the evidence again, because we're thinking about with this thing gets to litigation, how do we prove that we had reasonable efforts to force our licensee to mark? Build that evidence up for the future. For example, with the marking provision, include a reporting requirement that forces the licensee to come back to the licensor and show them that they've been marking. Obligate the licensee to reject goods that are being produced under the patents that are not marked. I think another thing that became clear in the case law is that follow up with the licensees, have a written record of following up with the licensees, and be prepared to enforce those rights, enforce their agreement to mark. And finally, consider a warranty provision where, for example, a licensee, if they fail to mark, and then the licensor enforces their patent subsequently and loses a chunk of damages because that licensee failed to mark, that the licensee agrees to effectively make up the difference. I think if with a policy like that in place, a licensee would take this marking issue a lot more seriously than they often do today. So with that, we're going to move on to slide 29 in cybersecurity and data privacy.
So a couple of things I wanted to touch on real quick, and we'll elaborate more on the next couple slides, are, cyber is one that's cyber and data privacy have kind of come up as a larger and larger topic in these technology agreements over the last couple of years, especially as more and more incidents have happened, breaches have happened, loss of data has happened, hacking has become more prevalent. Malware is one that's, taking the public services by storm, especially cities and companies. So it's definitely started to become more of a forefront issue in these agreements. And dealing with technology agreements, you're almost always dealing with some type of data. So it depends on whether or not you're going to need to incorporate some type of data privacy or cyber privacy provisions into an agreement, either provisions you want to have in there if you are the customer, or if you're a service provider, things you want to ensure are in there. So the first thing is, which side of the agreement are you on, and whether or not you want to have stronger provisions or somewhat pulled back provisions on these things. And just a couple of terms when you're dealing with this is, there's two basic buckets. They're opposite sides of the same coin, but essentially the same. They have a lot of similarities, but they're not the same thing. One is data privacy. There's all 50 states as of last year now have some type of data privacy law on the books. Many cities have started to get into the game, and they actually have privacy laws on the books. And there's local municipalities that now have it. And in addition to that, there's the international GDPR over in Europe, which is another one that focuses on data privacy. Problem is there's no federal regulation for one aspect of data privacy. And that aspect is whether or not you're in the financial or health, then there is federal law. If you're not in financial services or healthcare industry, then there's not. Then you fall under one of the 50 state data privacy laws. And while some of the laws have some similarities, there's a lot of differences between the laws. And, I'm not going to try to get into all the nuances of it. We'll touch a little bit briefly on some of the aspects, but just know that there is 50 different state laws. Again, there's cities that have it, there's municipalities that have it, and it never reflects on where your company is located. It reflects on the information you're gathering. If you're gathering information for someone that's a resident of Arizona, then you will be subjected to Arizona law. If you're gathering data for someone living in Florida, then you have Florida law. toggling away from privacy, you have data security. And data security, that is one, there's no federal law on the books. The FTC there actually is one that looks a lot at that. And very recently, you may have heard of, Facebook is about to get fined by the FTC. I mean, it's one where they kind of try to regulate whether or not there's the proper controls in place over private data. In addition to that, there's many states, 26, I believe was as of last year, that have some type of law on the books. The most stringent right now is the Massachusetts law. So everybody tries to model themselves a little bit off of, that law when they're doing these type of agreements and making sure, again, depending what side you're on, making sure you have adequate security controls and measures in place to meet, the most stringent law on the books is what you typically want to try to do. With that, Aaron, did you have some comments on this slide? Before I move on.
Yeah, just digging into data privacy and data security a little bit, very high level. They're inextricably related, but data privacy concerns the protection of personal information specifically. So that could mean an individual customer's name and address, or an email address, or it could mean information that the customer inputs into the software. So if you have software that serves an electronic health record, obviously the data that's being input is going to involve names and personal information. And any combination of elements that could lead to the identification of, or could plausibly lead to the identification of an individual, in most definitions of personal information, that would be what makes that's what constitutes personal information and brings all these data privacies into concern. Data security concerns the physical security of such personal information and any information provided by the customer that is processed by the software. So data security is generally not a major concern if you're only dealing with on-premise licenses, because that's being hosted either by the licensee or on the licensee's by a third-party agent on behalf of the licensee. So for the service provider, there would be no major data security concern there. Data security contract terms are of great concern when the service provider is using, storing, or processing the personal information, like in the example of the electronic health record. So that means the service provider is either hosting the on-premise software itself, or it's providing it as a software as a service, which is either hosted by the service provider itself or a third party. I think we can move to the next slide.
Okay, so toggling back to the data privacy, and like Aaron was just talking about, data privacy, there's different flavors of it. As I mentioned, there's the health sector, the financial sector, and Aaron was just talking about personally identifiable information, which we'll talk a little bit about bullet 2 first. There, it depends on when you're setting up these type of agreements and you're looking at that portion of the definition is what law you're falling under. If it's under the financial, then it's typically, sensitive personal information is what they typically, or non-public personal information is another one. If it's under health, it's, protected health information. And if it's neither of those, if it's, more general data that's being transferred, customer data, for example, if you're a sales company, it falls under what they call personally identifiable information, which is, it has to be, most state laws require it to be, as Aaron mentioned, it's usually a name and something that's not public. If it's just something that's publicly accessible or something you can find publicly and that information gets out, then that typically doesn't toggle into a breach of one of these license provisions. But if it is data, if you're hosting data of all your customers, and in addition to the customers, you have their social security number. Well, now you do have something that's very private that shouldn't be out there. It's not something that somebody can go publicly access, doing a Google search. So there you do have some type of a personally identifiable information, and that's something you'd want to protect. So when you're talking about the definition of personal information, you want to make sure it's not too broad, but you also want to make sure it's not too rigid. So if you're a sales company, you're going to want to make sure that the definition only includes customer names and non-public information, social security numbers, for example, if that's what you're collecting. If you're not collecting that, it's very unlikely that you're going to need to put a lot of these provisions into an agreement. So you first you have to know what you have, and then you have to know how you want to define it. Another thing you want to look at is you want to define incident versus data breach. I mean, an incident could be, an employee accidentally, looks at information they shouldn't have looked at. That's an incident, but it didn't get out there. So it's not really a breach where you're going to trip on a lot of these state laws where notification probably is required. So when you're doing these type of agreements, you want to make sure you're defining incident and breach, and you don't want to mix the two terms because they do mean different things. So that's something else you want to keep in the back of your mind. The last point I want to talk about with definition real quick is concepts like harmful code, which is becoming very prevalent and something that's popping up a lot, like malware, viruses, backdoors, hacking, remote access. All these things you want to set up in your definition so that you can use it later through the provisions of your agreement to make sure that if one of those incidents do occur, that you have coverage or that the proper person is providing coverage for that incident. And tagging up to the first one here, confidentiality, in the scope of confidentiality provisions, you want to consider the nature of the information that's being exchanged, like we just talked about, whether it's financial, whether it is banking, whether it is personal identifiable information. You want to know what the information is, and then you want to make sure you have appropriate and general confidentiality provisions in this, agreement to handle that data. It should be mutual where both parties have confidential information being exchanged between them, that there's some safeguards and that there's some provision in there to handle that. If someone's collecting the PII, let's say you're hosting this stuff on Amazon services, then you're going to want to make sure that whoever the vendor is that's collecting this data is storing it, processing it, and transmitting it to the Amazon service in a secure manner. You want to make sure that there's language in there if you have a supplier coming in and working on site and you're setting up this agreement. You want to make sure that there's permitted uses of confidential information, that if they're able to access certain things, they're not able to, make copies and take it out, and all of a sudden you have an exposure that way because of, an accidental third-party vendor coming onto your site. Storage and communication is another one that you want to put up in these agreements, where again, how the information is being transmitted. You don't want someone who has access to this information to be just blindly sending it over an email system or putting it into a Dropbox folder or some other method that is possibly insecure, could be breached, and all of a sudden you're set up and exposed. The last thing about confidentiality is I just want to touch on real quick is the return and destruction obligation. And what I mean there is, all contracts end at some point, and hopefully there's a successful non-disclosure of information, but at the end of that period, you want to make sure whatever information, whatever personal identifiable information, whatever financial service information, whether healthcare information, some third party or some vendor may have, it's properly disposed. It's not just, sent out and put on a thumb drive or transmitted back to you. If there's printed copies, it's not just thrown into the trash. I mean, there's lots of ways this data can get out after the end of the contract, and you want to make sure that there is some obligation by whoever has the information to properly dispose of it so it doesn't cause a data breach at the end. The next thing you kind of want to look at in these provisions is the incident response. And here, incident response plans is something that could be either an addendum to the agreement or it could be something that's incorporated into the agreement. And that's usually where whoever you're working with is going to have some type of team set up. They're going to have a whole method set up where they're going to go through, and if a breach occurs, it's basically the roadmap, the steps of how they're going to respond to it. And, with a lot of these state laws, federal laws, international laws, local laws, there's very short window, typically 30 days to respond to a breach. So you want to make sure that the incident response plan, the incident response is well defined within the agreement. It's structured so that it's meeting all the state laws. The notification and reporting regarding the incidents or data breaches is handled in the proper way. Proper authorities are notified, whether it be credit bureau agencies, whether it be customers, whether it be local law enforcement or federal law enforcement. You want to make sure that's all well defined and set up in these provisions for the data privacy. And the last thing is the remediation and mitigation. And here, this is starting to become a very big sticking point in these agreements because you have all this reporting that has to happen after a breach. So who's going to pay for it? A lot of people go, well, I have cyber insurance coverage. Well, the issue that's coming up now is depending on, whether it's an incident where something isn't disclosed, but you had a forensic analysis done to make sure that there was no breach, that might not be covered by your cyber policy or by, the other party's cyber policy. They might not cover notifications. They might not cover notifying government agencies, or even worse, if you do notify the government agency and there wasn't a breach, that might be not only who's going to handle the reporting, how it's going to be paid for, who's going to cover it, and whether that coverage is sufficient. If it's going to be the insurance policy, making sure the insurance policy clauses are in line with your agreement so that you are guaranteed coverage and that this isn't coming out of pocket, because there's a lot of costs once these breaches occur that will be incurred, and you just want to make sure you have the proper coverage for it. Aaron, before I move on, did you want to touch on a couple of these points?
I think in the interest of time, I'll skip my comments on this slide.
Sure. So I'm just going to move very quickly through the last couple slides here. If we move to data security, like we talked about, is more about the system as opposed to the data that's residing on the system. So when you're doing these agreements, you're going to want to just make sure you have strong measures in place. You're going to want to make sure, maybe look at the Massachusetts law and look at what's required there. You're going to want to make sure, your data secured in motion, meaning transit or at rest when it's residing on a server. You want to make sure you have, strong encryptions in place, data backup, disaster recovery. In the health industry and in the financial industry, you're going to have certifications being met of industry standards. So you're going to want to make sure all those things are in place in your agreement. If we move on to the next slide. So the other thing you want to look at that's very important with cyber and data privacy is the reps, warranties, and indemnification. And real quickly on the reps, you want to make sure that no recent security incident breaches were not disclosed to the purchaser. Yahoo a couple years ago got in trouble for this, where there was a breach. They didn't disclose it during the terms of an acquisition, came out later, and they got hit with a huge fine. You want to make sure the vendor has information security programs in place as required by the agreement. You want to make sure that, when you're doing the due diligence on an acquisition, that all the answers were true and complete. So there's a lot of things you want to put in the reps and warranties depending on, what the agreement is. So you just want to make sure that, if it's a vendor-vendee contract, that proper reps and warranties are there. And the last one I just want to touch on real quick, and I touched on it briefly a second ago, was the termination. Here you want to make sure, if there is a breach, who's going to be not only the party that has to respond, but is it something, if there is a breach, that either party can terminate the contract. You don't want that to happen at the onset of a data breach, because then you might be on the hook for covering everything. So you want to make sure that there's not only proper coverage, but the termination clause doesn't terminate on the onset of a breach. You want to make sure that there's a transition plan for winding up and transferring of data services back to whoever the right party is, and that it's done in a sufficient manner. Any hardware, third-party software, other spaces, other IP assets are either transferred back or they can continue operation after the termination of the agreement. So the termination clause is just another one besides the reps and warranties that I think is one that really needs to be scrutinized in these type of agreements. And for the interest of time, I know I'm going to cut it short and end it there. Unfortunately, I don't think we're going to be able to get to the last couple of sections. I hand it back to you, Laura.
Thank you so much to Brooks Cushman for putting together this presentation, and have a great day, everyone.